We talk about what a Terry stop is, we have to talk about what the Fourth Amendment is. The Fourth Amendment states the following: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrants shall issue, but upon probable cause supported by oath and affirmation, and particularly describing the place to be searched and the person or things to be seized. Although the courts have supported police officers' powers to make an arrest without a warrant, if they have probable grounds to believe the individual being detained has committed a felony or misdemeanor in their presence, arrests are nonetheless subject to the Fourth Amendment's requirements. Of course, before an arrest warrant can be issued, probable cause must be established, and it must be produced by circumstances that existed before the police officer stop, with what was learned later not being sufficient to constitute probable cause retroactively. There are situations, however, when a police officer's suspicion are aroused by someone's actions or manner, but there is insufficient probable cause to arrest that person. The Supreme Court in Terry v. Ohio permitted an on-the-street investigation by a police officer, which included patting down the subject of the investigation for weapons, with only Justice Douglas dissenting. Terry occurred after a police officer saw three people engaging in behavior that appeared to him, based on his training and experience, to be the casing of a store for a possible armed robbery. When the officer approached the individuals, identified himself, and did not receive timely identification, he seized one of the males, patted the outside of his garments, and discovered a revolver. The Fourth Amendment was relevant whenever a police officer accosts an individual and restricts his freedom to walk away, wrote Chief Justice Warren for the court. Because the warrant provision does not apply to the type of on-the-street encounter that occurred in Terry, the question was whether the officer's actions were justified, according to the Chief Justice. In this type of situation, the test of reasonableness is whether the police officer can point to a specific and articulable facts that, when combined with rational inferences drawn from those facts, would lead a neutral magistrate on review to conclude that a man of reasonable caution would be warranted in believing that possible criminal behavior was present, and that both an investigative stop and a frivolous search would be warranted. Because the police officer's actions led him to assume that an armed robbery was imminent, he was also made to feel that the guys were armed and likely violent, and that a frisk was necessary for his safety. Because the purpose of the frisk is to find deadly weapons, it must be limited to an intrusion that is reasonably tailored to find guns, knives, clubs, or other hidden instruments for the officer's assault. In a subsequent decision, the court decided that an officer may confiscate an object if plain touch reveals its presence during a weapon search and the officer has probable grounds to suspect it is contraband. The court compared the scenario to the plain view concept, which states that while evident contraband may be recovered, a search may not be expanded to assess if an object is contraband. Physical manipulation of a bus passenger's carry-on luggage kept in an overhead compartment without reasonable suspicion is also prohibited. Terry did not rule out a number of issues, including the circumstances under which an officer may lawfully stop a person on the street or elsewhere to ask questions, rather than frisk for weapons, the right of the stopped person to refuse to cooperate, and the police's permissible response to that refusal. In 2004, the Supreme Court gave a partial solution when it upheld a state statute requiring a suspect to reveal his name during a legitimate Terry stop. The court emphasized that questions concerning a suspect's identity are a common and expected feature of many Terry stops. Following Terry, the bar for investigating stops became one of reasonable suspicion of criminal behavior. This test allows police officers to stop and interview people without probable cause in order to investigate the basis of their concerns. The court was originally conservative in recognizing valid basis for reasonable suspicion, notwithstanding the fact that it did not construct a set of rules to regulate the implementation of the criteria. Although the court has held that an unsubstantiated anonymous tip is insufficient basis for a Terry stop, and that there is no firearms exception to the reasonable suspicion requirement, extensive intrusion on an individual's privacy, such as transportation to a station house for interrogation and fingerprinting, were invalidated in the absence of probable cause. However, the courts have recently taken less stringent methods. It took the court some time to come up with a standard for determining when a seizure had occurred, and the court recently changed its mind. This is a significant issue because it is at this stage that Fourth Amendment safeguards kick in. The Terry court stated in dictum that not all personal interactions between police officers and citizens result in personal seizures, and that only when the officer has in some way restrained the liberty of a citizen by the means of physical force or show of authority may we conclude that a seizure has occurred. Years later, Justice Stewart proposed a similar threshold, stating that a person is taken only if, given all the facts surrounding the occurrence, a reasonable person would believe he is not free to depart. Following that, a majority of the justices approved the reasonable perception criterion and applied it in various situations where the omission of evidence hinged on whether the person had been detained without probable cause or reasonable suspicion previous to the discovery of the evidence. When INS agents conducting workforce surveys within a garment factory to identify unlawful present aliens, for example, no seizures occurred. Although some officers were stationed at exits, others systematically traveled around the facility and questioned personnel. Even with obstructed exits, this brief interaction amounted to traditional consensual contact rather than Fourth Amendment seizures. When police in a squad car drove alongside a suspect who had turned and sprinted down the sidewalk when he spotted the squad car approaching, the court concluded that no seizures. The police behavior would not have signaled to a reasonable person on an attempt to capture or otherwise invade upon one's freedom of movement under the circumstances. No sirens, flashing lights, display of a weapon, or blocking the suspect's path, the court held. Soon after, the court moved from the Mendenhall reasonable perception criterion in favor of a more formalistic approach, finding that a real chase with the apparent purpose to capture did not constitute a seizure since the suspect had not obeyed the officer's command to halt. Mendenhall indicated a necessary but not sufficient criterion for a person seizure by demonstration of power. According to the court in California v. Hodaria D., the court held that a Fourth Amendment person seizure is the same as a common law arrest. Either physical force or the laying on of hands or compliance to the assertion of authority must be used. However, there are indications that Hodaria D. did not herald the end of the reasonable perception test, but rather carved out an exception for chases and maybe other confrontations between suspects and police. Later that year, the court decided that the Mendenhall free-to-leave inquiry was inappropriate in the circumstances of a police bus sweep, but that a modified reasonable perception approach still applied. During a bus sweep, police officers boarded a bus during a layover at a terminal and asked to search tickets, identity, and sometimes bags of selected passengers in order to detect illegal substances and their couriers. Instead of focusing on whether an arrest had occurred, as the Hodaria D approach would have required, the court argued that the proper question to ask is whether a reasonable person would feel free to refuse the officer's request or otherwise end the contact. The court explained that when a person is sitting on a bus and has no desire to leave, the degree to which a reasonable person would feel he or she could depart is not an accurate measure of the encounter's coercive effect. The Terry condition of a legitimate investigatorial stop is met in a traffic stop when it is legal for the police to keep an automobile and its occupants pending an investigation into a traffic violation. The police are not required to think that any of the vehicle's occupants are criminals. In the 2011 case, Floyd versus the City of New York, the courts concluded that the New York stop and frisk policy violated the Fourth Amendment by making stop and frisk more common for blacks and Hispanics.